This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we've got Todd Lutsky live in studio here to answer your estate planning questions. Phone lines wide open right now at 888-205-2263. That is the number to call to ask Todd your estate planning questions live on air. Again, it is 888-205-2263. Remember, we can usually get to about 2 or 3 of your calls. So make sure you get in line early so that you can ask Todd your estate planning questions. Again, that number is 888-205-2263. Mr. Lutsky, how are you doing today?
I am never better. How are you?
I'm good. Did you see that
No.
these scientists, they tried to cross a cheetah with a crab?
A cheetah and a crab?
Yeah.
That doesn't seem like a good mix.
No, it went sideways real fast.
Yeah, I bet so. I bet so.
Not great. Todd, let's talk a little bit about revocable trust today. Everyone likes to talk about like the big brother irrevocable, like, oh, like I'm the irrevocable trust. Revocable trusts.
Yes.
What can they accomplish?
So they can accomplish certainly, estate tax planning. They can accomplish avoiding probate, and they can accomplish, dynasty trust planning. They can allow you to continue to control the asset after you die for a very long time. Some states have no rule against perpetuities, means it can go on forever. Not Massachusetts, of course. It allows you to do it, but only up for about 100 years, give or take, is the rule about how long it can last. But it can also help you skip generations, meaning you can do generation skipping tax planning where you can take care of the family, protect from creditors and divorces, and still make it go to another generation without paying any estate tax at each generation. So to me, generational building wealth is phenomenal. And I think also it's important when we talk about, we always talk about irrevocable a lot, but with revocable, like with irrevocable, there are many kinds of trusts. There are many kinds of irrevocable trusts. Even with the revocable world now, there's, the idea of 2 trusts versus 1 trust. So we got to think about that as well.
Talking with Todd Lutsky from Cushing & Dolan. Again, phone lines are open for you to ask Todd your estate planning questions. The phone number is 888-205-2263. Again, that is 888-205-2263. Still have a little bit of space there for you to ask Todd your questions. Again, it's 888-205-2263. Todd, these revocable trusts, on a daily basis, what are changes that people would notice from how their finances worked before, and what stays the same?
Yeah, and I think that's part of the beauty of revocable trusts is that they are really simple. You don't have any separate income tax returns to file. So let's, like you say with your finances, let's say I put my investment portfolio inside the trust. Let's say I put my bank account inside the trust. What's going to happen? Am I going to not have access to my money? Absolutely not. So the difference is the name. Let's say the name on my investment account, if it was in my trust, would be, call it maybe if I'm doing a joint trust, it might be the Lutsky Family Trust. Okay, that's all that you're going to see. The difference is you're going to see that on your statements that you get from your investment advisor. And your access is exactly the same. Your investments are exactly the same. And since that account might have the Lutsky Family Trust as the name, it'll have my Social Security on it. So there's no income tax returns that need to be filed. Just keep filing your own 1040, just like you always do. So really becomes, just simple and uneventful for you, which is what we want when we do our planning.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you've got a question for Todd, 888-205-2263 is the number to call to ask him your question live on air right now. We're going to take a quick break, and when we come back, we'll get to your questions with Todd. That phone number is 888-205-2263. 888-205-2263. Again, it is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Todd Lutsky answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
Talking with Todd Lutsky, you got a question for Todd? The number to call is 888-205-2263 to get your estate planning question answered. Again, that is 888-205-2263. Let's go to Mark in Danvers. Mark, you are on with Todd Lutsky.
Good morning, guys. Great show.
Thank you.
Question, you were talking about revocable trust.
Mm-hmm.
And you had mentioned that the trust has no Social Security number assigned to it. Does that mean you do not have to pay capital gains on the trust if you put investments in there?
Well, I'm sure there was a miscommunication on how we did that. By the way, I love your creativity. So awesome. I'd love to figure out ways not to pay tax. Unfortunately, what I said was that the revocable trust does not have its own tax ID number, so you're correct about that. Instead, like if it was the Lutsky Family Trust, it would have my Social Security number on it. Okay, so the beauty of the trust is that when you put your investment portfolio in and your bank accounts in, and I don't care if it's a rental property, etc., that the trust itself is not going to have to file an income tax return. So many people think that, when you put assets in a trust, that you pay higher taxes, not no taxes. They say, I heard that you put assets in a trust, you have a much higher tax rate. So let me explain what that means. First of all, with revocable trusts, that's not the issue at all. With irrevocable trusts, it can be if it's not a grantor trust for income tax purposes. So if you put it in an irrevocable trust and it's not a grantor trust, when I say they have higher tax rates, if you make more than, and this number changes a lot, I think it's somewhere around 14,000, maybe a little higher. If the trust earns a little more than that in income, interest, dividends, capital gains, it's at the top tax rate, whatever that 39%, 37% tax rate federally. Whereas with human beings, our tax rate, we don't get into that tax level until we're in the hundreds of thousands of dollars, depending on whether you're married or single. So that's what I mean when I say trusts can have higher tax rates and be compressed as they are. But in the revocable trust situation, the beauty is we don't have to worry about that at all. You don't have to file a tax return, but it's not that good, unfortunately, Mark. I wish I could make it as good as you like it. The trust doesn't pay the gain or the tax. I do. The grantor does. The person who creates the trust does. So it just continues to be taxed in my Social Security number at my rates on my tax return on my 1040, and I don't have to file a tax return. So to me, that helps it to be what I like to call simple and uneventful in my life, not disrupting my life. And folks, that's important because that really leads me into a brand new guide that we've never given away before. It's one that the BBBA passed, as we all know, and it really just drives home something that we've been doing at Cushing and Dolan for a long time, joint revocable trusts. And it's catching on now. People are realizing that it is important. And for a lot of people with, what's a moderate estate these days? Under like $15 million. The exemption federally is going to go up because of the passage of the new act. And it's going to be $15 million January 1. Well, for a lot of people, I don't have to give away stuff anymore. I can keep stuff, avoid a 40% estate tax, and get a step up in basis when I die, eliminating the built-in gain that, like Mark was talking about, eliminating the built-in gain and winning on the 28.8% front. Wow. Even if I got to give mass 10%, I don't care. And these joint revocable trusts are so simple. You don't have to divide assets between husband and wife. You just fund them simply with all your assets at one time. And you can cram down way more assets than you could if you had two trusts. And they're really wonderful if you have large IRAs. Folks, learn about joint revocable trusts, how they work, the tax savings. it might be the way to go for you. 866-848-5699 or legalexchangeshow.com. Again, brand new guide, 866-848-5699 or legalexchangeshow.com.
Todd, we got another one for you here. Let's go to Martin in Springfield. Martin, what is your question for Todd?
Okay. My question is, I filled out a will. I'm 79 years old, and my concern is about probate. I'm from northern Vermont, but came down here to a senior community, and so that will is done. But my concerns are probate, and do I need to get a trust? How much does a trust cost? And you talking about revocable trust and irrevocable trust. I have an irrevocable trust for my cremation, and so
let me try to interject just so I can get your question answered. The irrevocable trust for your cremation, I'm sure has not. I don't think that's an estate planning trust, correct? I don't know what you did there, right? That's just something.
So I don't know anything. So
you only have a will, correct? That's the extent of your
right.
estate plan. Okay, so let's.
Only a will. Yes.
So one last question that might be helpful is: you said you came down here to a senior community from Vermont. Do you own real estate in Vermont still?
No.
Okay.
We sold the house, and from there I understand that it was real property because I own the land and the house. Here I own the house I lived in completely, but it's in a senior community, and they've told me that the land is owned by somebody else.
Right, I got it. I understand. So basically, in these senior communities, you get to you kind of get a place to live, but you don't own the property. I totally get it. So that may not be an issue then. So you may not own any real estate in Massachusetts, which can be helpful, I guess, from an avoiding probate standpoint. So from your point of view and your question, let me help others that are listening too. If he owned real estate in Vermont and in Mass, his question is doubly important. I want to avoid probate because when you own real estate in multiple states, you got to go to probate in multiple states, even though you're not a resident of the state in which you own real estate. So that's important. Sounds like for you, Martin, however, there's no Vermont real estate, so you don't have to worry there. And it sounds like there's probably no Massachusetts real estate because you own it in this senior community and you just have an interest in the house. Basically, you just have that house. Now, other assets you might own, we have to think about, which would be investments, stocks, bonds, mutual funds, IRAs. So to the extent all you want to do is avoid probate and you're not concerned about estate tax planning or nursing home planning and protecting assets, you can kind of do that if you have no real estate by simply making sure these accounts all have designated beneficiaries on them. If they do, they will pass to those designated beneficiaries outside of probate. Still subject to estate tax, but if you're under $2 million here in Mass, you're not going to have any estate tax to worry about, and that would successfully help you avoid probate, again, assuming no real estate. But a lot of times, and I heard you mention that maybe it's an irrevocable. Well, if you want to protect assets from a nursing home, then you kind of need to think about an irrevocable trust and putting some of these items into the irrevocable trust so that they will be protected from the cost of long-term care. And by putting them in there, yes, it takes 5 years, but it's immediately protected from, or immediately avoids probate when you pass, right? So what I like to tell folks a lot when they just have a will is really a won't. It's better than nothing. It certainly will direct where your assets go, but it goes to probate. And it will not help you reduce estate taxes. So if you're married, you're not going to shelter estate taxes. And it will not protect assets from a nursing home. So it won't avoid probate, won't reduce estate taxes, and won't protect an asset from a nursing home. But it will say where they go. So if that's all you want, that works. And if you want to also then just throw in the avoidance of probate, at least in your case, Martin, I think naming the designated beneficiaries on these investment accounts and brokerage accounts and bank accounts will get you there. Hope that helps a little.
Mr. Lutsky, thank you so much for the time. We appreciate you joining us today.
It is always my pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.